So students, we discussed about the importance of the Companies Act 2013. Why was it introduced? What is the definition of a company, characteristics of a company, etc. Now this chapter basically covers two sections, section 1 and 2. Section 1 gives us information about the short title, extent, commencement and application of the act. So a mnemonic here, SECA, to help us remember the provision. SECA, S is for short title, extent, commencement and application. The short title of the act is the Companies Act 2013. Previously we discussed the long title of the act. What was the long title? Long title and preamble are one and the same over here. It is an act to consolidate and amend the law relating to companies. So that helped us to understand that this act is for companies only and it does not apply to any other form of organization. Long title basically describes the enactment. Okay, it gives us slightly more information, detailed information as compared to the short title. Short title only identifies. Okay, I'll just write it over here. Short title merely identifies the enactment. It is mostly for convenience only. Okay, it is mostly for convenience. All right. So the short title, it identifies the enactment. Like over here, the short title says that this act is the Companies Act 2013, whereas the long title will actually describe. So I'll write over here, the long title describes the enactment. In case of confusion, we generally refer the long title or the preamble of the act. If you want to see how it was notified, I have an image here. So this is an act to consolidate and amend the law relating to companies only. This is the preamble as well as the long title of the act. Preamble, it specifies the scope, object and purpose of the act. Why was this act introduced? What was the purpose of this act? So this act aims to consolidate and amend the law relating to companies, something which we discussed last time. So this act is also known as the Companies Act. So the short title identifies the enactment and says that it is the Companies Act 2013. What is the extent? The act applies to the whole of India. All right. Commencement, when did the act commence? So we discussed that it received the assent on 29th August. It was notified in the official gazette on 30th August. Section 1, it came into force immediately on 30th August. Whereas other sections, they were notified later on. Few sections like 98 sections on 12th September, 183 sections on 1st April 2014 and so on. So the Companies Act extends to the whole of India. This won't be asked in the exam, so it's not important for us. But yes, sometimes in a case-based question, they may, test you on this concept, whether you know the applicability or not, the extent of it. The first section, it came into force immediately, and other provisions, they were notified by the central government through notification in the official gazette. Applicability, yes, important. Now this act applies to the companies which were incorporated under this act. This act means the Companies Act 2013. But it also applies to the companies which were incorporated under any previous company law like 1956 to 1913 and so on. Now Tata Steel was incorporated in the year 1907. Reliance Industries was incorporated in 1973. Infosys 1981. Can they say that since we were incorporated before 2013, the 1956 Act will apply to us? No, Act has clearly specified that if the word company is used in the Act, it includes all the companies, whether incorporated under this 2013 Act or any previous company law. So you cannot say that the previous company law was more favorable to me, that Act will apply. The Companies Act 2013 covers all the companies, whether incorporated under this act or any previous company law. It also applies to other sectors like banking, insurance, electricity. Okay, so it is applicable to other sectors like insurance, banking, and electricity. So let me write and make notes on the left hand side of the margin so that, when I revise these provisions, immediately those notes will help me to recall the concept. So this is how you make notes for yourself. Okay. So it also applies to insurance companies. It covers these sectors also. So the insurance companies, banking, and electricity. So write along with me. It also applies to other sectors like insurance, banking, and electricity. But the act excludes the companies if there are sections which contradict the act under which these companies were formed. So let's say, for example, that we are talking about an insurance company. So an insurance company is regulated by the Insurance Act 1938. I'll highlight it. The Insurance Act, the IRDA, that is Insurance Regulatory and Development Authority Act. So these are regulated, they are governed by the respective acts. Now, if there is some contradiction in the provisions, like Companies Act is saying something and their respective act is saying something else, then their respective acts will prevail. So the special acts under which these companies were formed, the special acts under which these companies are regulated, that act will prevail. So if you read the sentence properly, students, insurance companies, except where the provisions are inconsistent with the provisions of the Insurance Act or the IRDA, then in that case their respective act will prevail. So what is the meaning of the word except where? See, this word is used in every sentence. So what I have done is I have explained the meaning also. Let's read that. It means that if any provisions of the Companies Act is inconsistent, we will highlight this word because it is important for us. If there is inconsistency, if there is a contradiction, then in that case, with any of the provisions of the other act, be it the Insurance Act, Banking Act, or the Electricity Act, by which the company is regulated. Regulated word is important for me. You have to write that in the exam if a question is asked on this. The word regulated is the key word. Okay. So what are the two words which we identified? One, if there is some inconsistency. Second is inconsistency with what? Inconsistency with the provisions of the other act under which these companies are regulated or governed or formed. You can use any word. Then that company shall comply with the provisions of that respective act or acts, because see, in insurance there are two acts, no, which govern it. So by the respective act by which it is governed and regulated by. So I want these words to be mentioned in your answer. So these are the keywords. You will highlight these keywords because they have to be present in your answer. So use such legal terms. See, don't write just to under which these acts are managed. Don't use such simple words. Governed, regulated. These are the words which are expected by the examiner, and this will help you to get exemption. So if there is any inconsistency, okay, Companies Act is saying something and their respective act is saying something else. Companies Act, please move 2 steps backward. Their respective act will prevail. So that is always on priority. All right. So these other sectors like companies which are in the insurance business. So you may have like United India Insurance Company Limited or ICICI Prudential Life Insurance Company Limited. So these are companies which carry on the insurance business. Although they are companies, but they are regulated. They are governed by their respective act. They are formed under the Insurance Act and the IRDA Act. So their acts generally prevail. If the provisions are same, Companies Act and their respective act, they are both on the same page, then there is no issue at all. But if there is some inconsistency, then their act will prevail. So the Companies Act also applies to companies under performing under different sectors. Banking companies like you have Axis Bank, ICICI Bank, they are governed by the provisions of the Banking Regulation Act. You need not remember the years. That is why I'm not covering that. Companies engaged in electricity, okay, generation and supply of electricity. They are governed by the Electricity Act. So you have companies like Reliance Power, Tata Power Company. Although they are companies, but they are regulated, they are governed by their respective act. All right. Then we have any other company, I will go on highlighting, governed by special act for the time being in force. So companies like LIC, RBI, SBI. So LIC is formed under the LIC Act. Okay, so since it is formed under that act, it is governed by the provisions of its act. So although they are companies, they are considered as companies, the Companies Act will apply, but if there is inconsistency, their act will prevail. So any company governed by special act, a body corporate, we'll highlight that also, a body corporate incorporated under any act for the time being in force. Now, what is the meaning of a body corporate and how is it different from a company? We will be studying that with the help of a beautiful table, and it is very easy to understand through that table. So we will be covering that concept. Body corporate is defined under section 2 clause 11 of the Companies Act 2013. So I'll be covering the definition and the difference between over there. But it is a very simple concept. Try to understand. Body corporate means having the features of a corporate. That is, it is having corporate status or a corporate structure. Every company is a body corporate, but every body corporate need not be a company as per the Companies Act. Okay, so there is a difference. We will be studying that. So even if you are a body corporate, the Companies Act will apply. For example, companies like Food Corporation of India, National Highway Authority of India, the Companies Act applies to them also. But the common provision always remains. If there is any inconsistency, then their respective act or acts shall prevail. Okay, so their acts will be applicable. All right. Let us now continue and study section 2, which covers definitions. Definitions are given under section 2 of the Companies Act. You have total 95 definitions, but only 93 are covered in your module. There are few definitions which are not covered, but I have just mentioned the name because I want you to learn the clauses in a story format. So I'll teach you how to learn these clauses in a story format. I'll give you the story. But if I want you to learn all the clauses in a sequence, I also need to include the clauses which are not covered in the module. Now, I can't expect you to remember after 3, 4 is not there in the module, so I need not remember that and then jump to 5. I will not be able to make a story if I leave few sections. So just for the purpose of remembering the clause numbers, okay, I have even mentioned the clauses which are not covered in your module, but I have written NA. It means you need not learn the definition of that clause. So you need not cover all the definitions, study only the ones which are important for exam, and I'll also highlight the ones which you need to memorize. Not all the definitions in the module are important. Okay, so on this note, let us begin and first understand why is it necessary to define a few words. Now, these definitional sections or clauses, they are also known as internal aids to construction. They are of immense help in interpreting or construing the enactment or any of its parts. Ma'am, we didn't understand anything. Don't worry. Let me give you a background first. Why are definitions important? Now imagine if there is no definition. Okay, the word is not defined anywhere in the act. I'll take a very commonly used word in the Companies Act, director. What if I don't define the term director? Every person reading the act will have its own interpretation of director. So in order to provide uniformity, okay, that is the main purpose why are definitions formed, to provide uniformity, so that every person reading the act understands the word in the same sense. Now, if I give you the act without defining the word director, you may say that, ma'am, director means a person who manages the company. Somebody else will say, ma'am, director means a person who takes decisions for the company. Third person will have another interpretation of the word director. So in order to bring a uniformity in understanding, we need to define a few terms. definitions are also provided in order to keep everything at one place. Okay, so to ensure that the meaning is kept at one place. And then wherever the word is used, it will have the same meaning. Now let's say, for example, so it also shortens, the burden or of the act. It makes it less bulky. Now, if I don't define the word director, wherever it is used in the act, I'll have to explain what it means because I have not defined it at one place. So imagine the word director being defined at every place it is used. It's not possible. There is a lot of repetition, okay? So at one place, and it also avoids. So instead of defining the term every time, I define it at one place. Also, it avoids ambiguity. Uniformity also helps to avoid ambiguity. All right. Now, how does it avoid ambiguity? See, if I give you the word board, okay, that is one word which we have defined in the Companies Act, board. Okay, or board of directors. Now, if I don't provide the definition of board of directors, there can be a lot of confusion. The board may refer to board of film certification. Board may refer to the board of secondary education. Board may refer to the board of a company. Now you will tell me, ma'am, why do you need to there's no need for confusion. You're studying the Companies Act. So obviously it is board of the company. Where is it written? Has it been mentioned anywhere in the act that they are referring to board of the company? It's not understood. If the word board is used, I may assume that the Companies Act is referring to board of film certification, or it is referring to board of secondary education. Where is it written that they are referring to board of a company? So in order to avoid ambiguity, confusion, we have defined the word board of directors or board, and see how well they have defined this word. In relation to a company. So they have clarified in the beginning itself that what the definition that we are providing, the term that we are defining is in relation to a company. So in relation to a company, it means a collective body of directors of whom the company. So board can be defined in context of any organization. So it can be board of a film fraternity, it can be board of some trust, it can be board of secondary school or secondary education. But here we are defining board with respect to a company. So in relation to a company, it means a collective body. So it cannot be just a single person. Okay, director can be a single person, but board is a collective body of whom? Of directors. Of which organization? Of the company. So it is a collective body. This is my keyword. It is collective body. Of whom? Of the directors. Of which organization? Of the company. So see, there is so much clarity which is given through the definition that wherever the word board or board of directors is used, it is in relation to a company. What is a board? It is a collective body of whom? Of the directors. Of which organization? Of the company. So this confusion or ambiguity is removed through the definition. Yes or no? So that is the use of the definition. Now, one last point. Now, all this is covered in the interpretation of statutes, which helps us to understand the language of law. Now, the word is defined by the lawmaker when the act was introduced. Yes. So the lawmaker had certain meaning in mind. Now, the person who is reading the act should know what was the intention of the lawmaker. That is why it is important to define that term in order to show that when the act was made, what was the intention of the lawmaker? When he used the word in the act, what did he mean? All that will be clarified through definition. Now, why is it known as an internal aid to construction? Firstly, let us understand what is the meaning of the word aid. Aid means help. Internal means it is specified in the act itself. So these meanings, these definitions are given in the act itself. That is why they are internal aids to construction. There are external aids to construction also. But these are internal because they are given in the act itself. What is the meaning of construction? Okay, first let us understand what is the meaning of interpretation and how is it different from construction. Interpretation means reading and understanding the act as it is. Understanding the act as it is. Reading the words, the provisions, and understanding it as the words are mentioned with the comma, with and or. Read it as it is and try to understand. If the meaning is clear, you need not go to the second step, that is construction. If the meaning is clear, there is no ambiguity. I don't need to apply my mind, logic, facts of the case. It's not required. But if I read the act as it is, and it is confusing, I don't think this was the intention of the lawmaker. I don't think that he wanted to read the word and as it is. Let's replace it with or. Let's see if it makes more sense. See, it is making more sense now. I think that was the intention of the lawmaker. So if we try to add facts and figures, maybe circumstance, like I'm not writing figures, it seems weird. So facts, circumstances. If I apply logic, does it make more sense? Yes, it does. Then that is construction. So Act says read the definition as it is. If it is clear, there's no need for construction. But if there is ambiguity, if there is confusion, I don't think this was the intention of the lawmaker. Go one step further. That is known as construction. So these definitions help us to interpret, helps us to understand the language of law. It removes ambiguity, it brings uniformity. It also tries to shorten the language of law. It says that if we have mentioned the word appointed over here, appoint also means that the authority can remove. Okay, so if I have the power to appoint someone, I indirectly have the power to remove that person also. So all that is understood through definitions. All right, students. So I'll erase this later if you want, so that we can write few more notes, because all this is not going to be asked in the exam. But this is why definitions are always provided in the Act, and the words are defined in the initial sections, maybe section 2 or 3, because we don't want you to have any kind of confusion before you start reading the provisions and the sections. So there should be absolute clarity. That is why these words are defined in the initial 1 or 2 sections. It is generally in section 2 or section 3 of the Act. Let us discuss the first definition. Now, clause 1 defines abridged prospectus. Firstly, let us understand what is the meaning of the word prospectus. We are going to study this definition again when we discuss prospectus and allotment of securities. Now, what is the meaning of abridged prospectus? Prospectus is required when you offer securities to the public. See, the public is innocent. They don't know anything about your company. You are asking them to invest in your company, to give their hard-earned money. You need to provide them some basic information, right? The document through which this information is provided to the public is known as a prospectus. But do you really think people have the time and the patience to read a prospectus which is either like 150 to 200 pages? We don't even read a textbook which is crossing 100 pages. So do you really think people are going to read the prospectus? No. See, they are only concerned with what is the dividend that you have been giving since these years. What is the profit projection? Who are the directors? Who are going to manage the company? What is the object of your company? How are you going to utilize my money? So there are few basic, there is a set of basic information which the investors are concerned with. They don't want you to provide more details. They just want you to be very specific. Law says that instead of issuing the complete prospectus, why don't you just give them a summary version of the prospectus? That summarized version is known as an abridged prospectus. But I can't write just like, what I feel. Law again wants uniformity. That is why we have defined what should be the contents of an abridged prospectus. And what is an abridged prospectus? That is also defined under clause 1 of the Act. All the definitions are arranged alphabetically, so it will be easy for us to go through all the concepts. Now let us highlight the keywords. I hope you're ready with the highlighters. Yes. The first keyword is that it is a memorandum. See, it is not the final prospectus of the company. It's just a memorandum. It's like, containing half information. So it is something which is not complete. It is just a memorandum. In Hindi, we say kacha pakka. It is not complete because it doesn't provide 100% information. But it contains such salient features. It contains the important features of a prospectus as are specified by SEBI. Okay, so I'll highlight a few words here. SEBI. Okay, so you need not remember by making regulations in this behalf. All that can be avoided. Your definition should be like around 80% close to the actual definition. Word to word is not required always. So it means, what is it? It is a memorandum. What does it contain? Salient features of what? Of a prospectus. Who tells what should be, who prescribes what should be included, what should be the contents? SEBI. So you are offering shares to the public, so SEBI will be involved. So it means a memorandum containing such salient features of a prospectus as may be specified by SEBI. So this is the third point which I need to remember. See, I'll show you how you need to break down the definitions and memorize it. So it is a memorandum containing such salient features of a prospectus as may be specified by SEBI. So easy to remember this way, right? Now, next let us discuss what is the meaning of accounting standard. Okay. Now you must have studied this in accounts. Now our accounting standards are based on IFRS. So our Ind AS, they are based on IFRS, that is International Financial Reporting Standards. Basically, we need to know how the transactions and other events are to be recognized, to be measured, recorded. We need standards. Now, why standards are required? Same logic, because we want uniformity. We want all the companies to prepare their books of accounts following a set of rules. Otherwise, what will happen? It will be difficult for me to compare the financials of two companies because each company may be following a different set of accounting. I don't want that. I want that each company should be following a set of depreciation methods or revenue recognition. So I want rules so that they are all the companies are following a standardized form of accounting. That is the main aim of introducing these accounting standards. Now let us go through the definition. It's not important for exam. It won't be asked in the exam. The definition of accounting standards, the logic of accounting standards will also apply to auditing standards, which we are going to study next. Let us highlight the keywords. So these are standards of what? Standards of accounting. So what are these? Accounting standards are standards of accounting. So let me write the word what. What are these? These are standards of accounting. Okay. So let's ask ourselves questions so that it is easy for us to remember what, why, how. These questions will always help our mind to think of the answer, and that is nothing but the definition. So what are these? These are standards of accounting or addendum. Addendum means additions. See, we have framed these accounting standards, but yes, there are going to be additions. There are going to be extra information which we provide. You can write that also. This is nothing but extra information. For companies or class of companies referred in section 133. So it will apply to certain companies and class of companies. What is mentioned in section 133? Section 133 says that the central government will prescribe the accounting standards. So we have given central government the authority to prescribe the accounting standards. So the final authority is with the central government. But what is the flow? Let me give that to you. ICAI, okay, ICAI will recommend. ICAI will recommend the accounting, as well as later we will study auditing standards, to NFRA. Now what is NFRA? The full form is mentioned over here. We will highlight it. Okay, I have not given it over here, but it is National Financial Reporting Authority. So ICAI will recommend the accounting standards to NFRA. The NFRA will examine it, and then they will recommend it to the central government. So the central government will, in consultation with NFRA. So NFRA has now gone through the accounting standards as referred by ICAI. They will examine it and they will recommend that to the central government, and the central government will, in consultation with NFRA, finally they will prescribe the standards of accounting. I will highlight so that it is easy for us to remember the provisions. So let's use different color pens and markers. The central government, so let me highlight that for you. The central government, now these color codes will help us to establish a relation between what is discussed. The central government will prescribe. Okay, so this word is important for me because who prescribes the accounting standards? Central government. The final authority is with the central government. What will they do? They will prescribe the standards of accounting. See, these are the same words which they have used. It is nothing new. So what will happen? The central government, what will they do? They will prescribe. What will they prescribe? Accounting standards. See, these are connected. Or any addendum thereto. Alright. As recommended by ICAI. So let me highlight that for you. Recommended by ICAI. So who recommends these accounting standards? ICAI. Then the central government will seek the consultation. Okay, after the consultation and examination of the recommendations made by NFRA, the words are confusing. You will not be able to understand who exactly recommends, and finally with whose consultation we are prescribing the accounting standards. But it is very clear through this chart. See, ICAI will recommend the accounting standards to NFRA. NFRA will examine them, recommend them to the central government. So that flow is very clear to you, I hope. Yes. So the central government prescribes the accounting standards which are recommended by ICAI, and then the central government, in consultation with and recommendation made by NFRA, will prescribe the accounting standards. But this was introduced in the year 2013. At that time, we were not ready with the composition of NFRA. So there was clarification given under Rule 7. So what is given in Rule 7? Rule 7 says, until the NFRA is constituted under Section 132 of the Act. We are going to study this in accounts of company later in the area of study. Okay. So as per Rule 7, until the NFRA is constituted, because that time we were ready with the definition. Okay, all this was prescribed. We were ready with who's going to prescribe, but we were not ready with the composition of NFRA. So there was a clarification that the standards of accounting, as specified under Companies Act 1956, they shall be deemed to be the accounting standards. Okay, so till we are not final with the NFRA, with the composition of NFRA, until it is constituted, we will continue with the accounting standards that were prescribed in the Companies Act 1956. The central government will then prescribe the standards of accounting. So again, the same color coding will apply here. The central government, okay, prescribes, all right, the standards of accounting or additions, addendum thereto, as recommended by ICAI, okay, in consultation with, now there was no NFRA, so who would recommend those accounting standards to the government? In consultation with and after the examination of the recommendations made by National Advisory Committee on Accounting Standards. So the same color coding is used. Earlier it was NFRA. Later it was NFRA, but earlier we had the National Advisory Committee on Accounting Standards. So let me write the flow for you so that it is easy for you to remember. ICAI would recommend the accounting standards to NACAS, and then NACAS would examine it, plus they would offer recommendation to the central government. Then the central government would, in consultation with NACAS, prescribe the accounting standards. But now I don't think this is relevant because NFRA has been constituted. We are ready with the composition of NFRA. So now I don't think this rule has any relevance. But yes, because it is mentioned in the module, so I thought that you should be aware of this. And some part of it you will also cover under Section 132 of the Companies Act. So we need to know about it. Along with this, we also have auditing standards. Okay, so it is the same. That is why I'm covering it now itself. Auditing standards means standards of auditing. All right, that was very simple. It means standards of auditing, or any addendum thereto. What is the meaning of addendum? Addendum means additional, additions you can say, or some extra information. For companies or class of companies, so it applies to companies or a class of companies. This you need not remember section 133. It is not going to be asked in the exam. Subsection 10, okay. The central government, let me make notes here. The central government, let me use the same color coding. The central government, okay, may prescribe, alright, the standards of auditing or addendum thereto. It is recommended by ICAI, alright, in consultation with and after the examination of the recommendations made by NFRA. So what will happen in this case? ICAI will recommend the auditing standards to NFRA, and then NFRA will examine it. Plus they will recommend it to the central government. So ultimately the auditing standards will be prescribed by the central government. Provided that until the auditing standards are notified, any standards or standards of accounting specified by ICAI will be deemed to be the auditing standards. So till NFRA was constituted, the auditing standards recommended by ICAI were considered final. But now after the composition of NFRA, the ICAI will recommend the auditing standards to NFRA, and then NFRA will recommend them to the central government. The central government, in consultation with NFRA, prescribe the auditing standards. Okay. So I hope you have noted this in your textbook. Done. You can pause the video anytime you want. After this, let us study what is the meaning of the word alteration as defined in the Act. Now, alteration, we will highlight it. It includes the making of addition, omission, and substitution. AOS. So, what is the meaning of alteration? Now, you will study this word like alteration of articles, alteration of memorandum, alteration of any document. What does it mean? So, alteration, it's an inclusive definition. It is not explaining the meaning. See, remember students, whenever the word means is used, okay, whenever the word means is used in the definition, it is actually defining the term, it is explaining the meaning of the term. But the word includes, it is only an inclusive definition which says that these things are included, okay. So it includes the making of additions, omissions, and substitution. Substitution means replacement. So you alter by either adding information, removing, that is omitting information, or substituting the information. That is alteration. Appellate tribunal is not defined in the Act. It is defined in the Act, not in the module. Then we have the definition of articles of association. Okay, what is the meaning of articles? Articles means the articles of the company as originally framed. This will happen at the time of incorporation. Okay, this will happen at the time of incorporation. This is the document with which the company is registered. Articles, memorandum of association. It also includes the articles which are altered from time to time. See, there are so many changes which happen in a company. So even though you are altering the articles, but wherever you use the word article, it includes that altered articles also. You can't say that no, articles only mean the one which was with which the company was incorporated. No, articles will also include the articles which you have altered from time to time. It also includes the articles which are applied in pursuance of this Act or any previous company law, like say for example, model articles. You did not prepare any article for your company. So law will automatically apply the model articles to you. That is also considered as articles of the company. So you can either adopt the model articles as it is, you can make changes, or you can have your own articles. What is the meaning of associate company? This we will study when I discuss holding and subsidiary company in the next unit. I don't want to discuss anything right now. You will understand this better when we study this along with holding and subsidiary. So I'll keep this on hold. But just remember the clause. It is important for exam along with the definition. It is important. We discussed auditing standards. Next, what is the meaning of authorized capital or nominal capital? Now, this is the maximum amount of money that we can raise by issue of shares. This is that amount on which we pay stamp duty. So you need to mention the authorized capital in your memorandum, because the amount of stamp duty is based on the amount of authorized capital. It's a percentage which we apply on the authorized capital. So it is the capital which the company is authorized by the memorandum. Where is the capital clause mentioned? In the memorandum. So the company is authorized by the memorandum. This is the maximum amount of share capital of the company. So this is the maximum that the company can raise. I want to issue more shares. I want to go beyond the authorized capital. Alright, you alter the authorized capital, alter the memorandum, alter the capital clause, and you can issue more shares. You can raise more money. Board of Directors defined under clause 10. Now, students, there is a separate video which will help you to remember all the clause numbers in a sequence. So, I am not discussing and concentrating more on memorizing the clauses over here. Video is different. I'll give you a story to remember. Now, just understand the meaning of the important definition. Okay. After this, let us discuss the meaning of body corporate or corporation. Now, the word corporation is actually derived from a Latin word, which is corpus. Okay, corpus is the Latin word which means body. Okay, corporation is derived from a Latin word corpus, which means body. So that is why body corporate is also known as corporation. Now, you remember I had mentioned a sentence that all companies are body corporates, but all body corporates are not companies. Why did I say that? There is a reason. I have a note for you. Let us discuss that first and then we'll come to the definition. I have a note for you. Here it is. You can copy this now to save time because it is not important for exam. I don't think they will ask you all this in the exam. So in order to save time, I have already written the note for you. You can just copy it. But first understand. Yes, first let us go through and then I will give you time to copy. An incorporated body. Now what is incorporation? It means coming into existence. So this is basically applicable for artificial persons because they don't take birth like a natural person. So you have to form them. An incorporated body owes its existence either to a special act of parliament. Okay, let me highlight this. So you can be formed either under a separate act of parliament or you can be formed under the company law. Okay, so if you are an incorporated body, incorporated means you are an artificial person. An artificial person can be formed either under a special act of parliament or under the company law. So corporations like LIC, SBI, etc., they have been brought into existence by special act of parliament. So LIC is incorporated under the LIC Act. Yes, LIC Act. Same goes for SBI. They are also known as statutory corporations. They are formed under a separate act of parliament. Yes, the Companies Act applies to these body corporates also. It also applies to companies which are formed under a separate act of parliament. But if there is any contradiction, then their acts will prevail. So an incorporated body can come into existence either through the act of parliament or you can be incorporated under the Companies Act. So companies like Tata Steel, Reliance, they have been formed, they have been incorporated under the company law. Companies Act applies to them. So these are those companies which are defined under the Companies Act in section 2 clause 20. So this is a company, okay? Whereas these are corporations. Both are covered under the meaning of a body corporate. That is why I mentioned that all companies are body corporates. But all body corporates are not companies because body corporate includes those corporations which are formed under separate act of parliament. That is also included in the term body corporate. Are you getting me? So all the companies are body corporates. But all body corporates are not companies because body corporate includes those corporations which are formed under a separate act of parliament. That is also included in body corporate. Is it clear? So you can pause the video now and you can copy this in your notebook. Don't take a picture or you will forget to write and it will remain in your mobile only. Please write this in your notebook. You can pause the video and write it. Done? Okay, let us continue. Now this is one small difference. It is a small table which I have formed on the basis of our discussion. What did I mention? That the word corporation is derived from a Latin word corpus, which means body. Generally, corporations are used for non-living or artificial persons. So corporations are legal persons. They are created by process other than natural birth. So they are artificial persons. Yes, we are clear about that. It is derived from a Latin word corpus, which means body. Now, what exactly is a body corporate? See, it is a corporate means it is having corporate structure, corporate status. What does it mean? It means it is just like any other living person capable of contracting in its own name. So, body corporate. Corporate means association of persons having the following characteristics. Like a person, it has separate legal status. Okay, it has corporate status. It is incorporated under any law, not necessarily the Companies Act. It is incorporated under any law for the time being in force. It has separate legal identity, perpetual succession, common seal. It can file a case can be filed. It can enter into contracts. It can sue in its own name. So these are the characteristics of a body corporate. Section 2, clause 11, I had mentioned this earlier. First, listen to me, students. I will give you time to copy. Section 2, clause 11 of the Companies Act defines the term body corporate. It's a very interesting definition. It says that body corporate or corporation includes, I have highlighted this word, it includes. It means that it is not an exhaustive definition. It is just an inclusive definition. We can include something else also. Yes. So it includes a company incorporated outside India. It is understood that companies which are incorporated in India are body corporates. It is already covered in the definition, but it also includes the companies which are incorporated outside India, may or may not having a place of business in India. So companies which are incorporated in India are body corporates because all companies are body corporates. But it also includes the companies which are incorporated outside India, may or may not be having a place of business in India. Extra point. If you are incorporated outside India, but you're doing business in India, you're a foreign company. Companies Act applies to you. So it includes a company incorporated outside India. So it is understood that a body corporate includes all the companies, whether incorporated in India or outside India, except a cooperative society. That is given in the definition. It does not include a cooperative society. It does not include any other body corporate. Okay, it does not include any body corporate notified by the central government. Something wrong with my voice. Fine. Okay. So it does not include a body corporate, cooperative society. It does not include any body corporate as notified by the central government. So basically it includes all the companies incorporated in India or outside India except a cooperative society. Now let us see how is a company defined. Company means a company which is registered under the Companies Act 2013 in India. So to be classified as a company, not a body corporate, just a company, you have to be registered in India. You also must have a registered office in India. Okay. So when will you consider yourself as a company? If you are incorporated in India and you have a registered office in India. I am incorporated outside India. I have an office outside India. You're a body corporate. You're not a company. Okay. Body corporate is therefore a wider term. Yeah, I agree. Because body corporate includes companies as well as corporations. Yes, which are formed under a separate act of parliament. Right? So body corporate includes both companies registered in India as well as outside India. But company includes only those entities which are registered in India. I have also given you examples over here. So we have Reliance Industries, Tata Steel, Infosys. They are all registered in India, having a registered office in India. But companies like Alphabet Inc., this is the parent company of Google, Microsoft, Facebook, they are all incorporated outside India. foreign company is a company not incorporated in India. But ma'am, they are present in India. Yes, dear, they are present in India through subsidiaries. So yes, because business has gone global. Now, for the ease of doing business, they have offices in India. But how do they operate in India? They form a subsidiary in India. So this is an exception. However, a subsidiary of such company, if incorporated in India, shall be considered as company by the Companies Act. Now say for example, you have Google India Private Limited. It is a subsidiary of the parent company. So that is considered, this is considered as a company. This will be considered as a company and the Companies Act will apply. It is covered under the definition of company. Whereas its parent company, Alphabet Inc., that is considered as a body corporate. Because it is incorporated outside India, having registered office also outside India. But the subsidiary incorporated in India and having a registered office in India, that subsidiary will be considered as a company to which the Companies Act applies. Same goes for PepsiCo India Private Limited. It is an Indian subsidiary incorporated in India, having office in India. That is an Indian, that is a company as per the Companies Act. Okay, students. So this is the meaning of a body corporate. You can pause the video and you can write. Right, chalo, likho. Done. All right. Continue writing. Then this. And the last part. Done? Okay. So let us continue. We were discussing body corporate. Okay. So body corporate definition I have already covered in that chart. Then we have the definition of book and paper, book or paper. So yes, this is a concept which we will study in accounts of company. Book and paper, book or paper, it includes books of accounts. Again, it is an inclusive definition. Deeds, vouchers, writings, documents, minutes registered, maintained either on paper or in the electronic form. So you can maintain books in the electronic form. You can have Tally, you can have any other system of maintaining these documents. You can store it in a floppy drive or a drive space, cloud, or maybe on a server. So it includes books of accounts, deeds, vouchers, documents. You need not remember this, but yes, it's covered in the subsequent chapter also. So we will have to remember. There is a way, a mnemonic which I have created for you. It's B, D square, V, add another V, it becomes W, invert it, it becomes M. Okay. So B is for books of accounts. D is for deeds, D is for document, V is for voucher, add another V becomes a W, writing, invert it, that becomes minutes. Okay, so B, D square, V, W, M. That is how you can remember. Next we have the definition of a books, yes, of books of accounts. This is important. It includes records which are many. So records word is important. What are books of accounts? They are records. Records for what? For money received, money spent. Sales and purchase of goods and services, assets and liabilities, items of cost, cost records maintained under section 148 for certain class of companies. So that refers to the cost records which are maintained by certain companies. So it includes money received, money spent. So we prepare the cash book for that. Sale and purchase. So we prepare the subsidiary books for that, purchase book, sales book, asset liability. We prepare the journal for that. Cost records are also maintained by certain companies under section 148. So what is included? Money received, money spent, asset liability, sale, purchase, asset liability and cost records section 148. Branch office not important for exam. Called up capital fairly important. It means the amount which has been called up. Okay. Charge. Yes, this is important. Do you know before the 2013 Act, the word charge was not defined at all. There was no definition for the word charge. It was defined for the first time in the Companies Act 2013. Definition is important and the clause is also important. Earlier, the definition was that charge includes mortgage. Now they have properly defined, it means interest or lien created on the property or assets of the company or any of its undertaking or both as security, and it includes mortgage also. So in simple words, charge means security. Nobody will give you loan for free. They want security. So we go to the bank, we obtain loan, they ask us to give security because nobody trusts. Na? What if I borrow money and then I'm absconding, I flee from the country? So what will they do? They will sell the assets, recover the money. So it is just to safeguard their interest. So it means any interest or lien on the property or assets of the company. So this is the security which we have given. You can give your stock, fixed assets, machinery, land, building as security and obtain loan. Chartered accountant definition is not important. Chief executive officer, not important. CFO, you just need to know the words. CEO is the one who has been designated as such and CFO is appointed as such. Okay. Next we have the definition of company given under section 2 clause 20. What is given under section 2 clause 20? Company means a company incorporated under this act. This act means the Companies Act 2013 and any other previous company law. I don't think I need to explain this because we have discussed this numerous times. So Reliance was incorporated in 1973, Tata Steel 1907, Infosys 1981, but Companies Act applies to them also. They are also considered as company. Then we have company limited by guarantee. What happens in this case? My liability is limited to the amount that I have guaranteed. When will I pay that amount? At the time of winding up. So it means a company having liability which is limited by the memorandum. Liability clause is mentioned in the memorandum. It is limited by the memorandum to such amount as the members undertake to contribute to the asset in the event of the company being wound up. Yes, we do have companies limited by guarantee, having share capital, not having share capital. We will be discussing that in the next unit. But as of now, we just need to remember that these are companies, the members of which decide to contribute the money at the time of winding up. Okay. Then these were notes which you have already written. Okay. Clause 22, company limited by shares. So let's say that I have shares of face value 100. I have paid 75 rupees per share. What is my liability now? Only 25. Can I ask the member to pay more? Can I tell him that, listen, we don't have money, will you pay us some more amount? We'll think of what to do with it. No. My liability is limited to the extent of unpaid amount on shares. So if the face value is 100, my liability is restricted to 100 only. I'm not going to pay anything more than that. All right. The liability is limited again. Where it is limited by the memorandum because the liability clause is given in the memorandum. So memorandum says that the liability of the members is limited to the amount unpaid on shares. Then company liquidator is not there in the module, contributory, although it is not important for exam, we will still study this. It is mentioned in the module also. Contributory, how is the word contributory defined? Now I have a small chart for you actually. We'll write it. Okay, that will be better. So in your notebook, you will write with me. Okay. We are discussing the meaning of the word contributory. Now, as far as a company is concerned, okay, in case of a company limited by shares, and here we have limited by guarantee. In case of company limited by shares, what is the liability we just discussed? The liability is limited to the amount. So liability, I'll put the arrow over here. Liability is limited to the amount unpaid on shares. Okay. So let's say that I have shares of face value 100 and I have paid up 75. Now my liability is only 25. if this 25 rupees is recovered from the member during the lifetime, then he is contributing this money as a member. Okay, he is considered as a member. But if this money is called from him at the time of winding up, then that person is known as, then he is known as contributory. So let's say Mr. X. Okay, Mr. X is the owner of one share of 100 rupees each. During the lifetime, if we call 25 rupees from him, then X is considered as a member. He is contributing as a member. This is nothing but your call money, right? As during the lifetime, this is your call money. Then that person is contributing as a member. But at the time of winding up, okay, if this money is paid at the time of winding up, then that same person is considered as a contributor. Okay, that's just a word used for them. So here he is a member, not contributory. Okay, but at the time of winding up, that same person is called a contributor. Is it clear? There is one very interesting part. Let's say that Mr. X is the owner of one share of face value 100. One share, okay, he owns one share. The share is fully paid up. Even then, at the time of winding up, he is known as a contributory, even though he is not going to contribute any amount because it is fully paid. Shares are fully paid. Although we will not recover anything from him, he will not contribute, as shares are fully paid. But he is still considered. However, he is considered, or he is known as. Okay, he is known as. That is the name which we have given him. He is known as a contributor. That is just a name which we have given him. Okay. Have you written? You want to copy this? I'll wait. Done? Okay. You can pause the video and write. Done? Okay. So this is the meaning of the word contributory. Let us read the definition. Contributory means a person liable to contribute. Okay, so he is, we'll highlight, liable to contribute towards the assets, but in the event of winding up of the company. For the purpose of this clause, it is hereby clarified that a person holding fully paid up shares in the company shall be considered, he will be known as a contributory, although we will not recover anything from him, although he is not liable because he is holding fully paid up share, but just a name given to him, he is known as a contributory. Next, let us discuss the definition of the word control. Not important for exam, but yes, since you will find a mention of this word in the definition of holding subsidiary, so it is important for us to at least go through the definition once. Okay, you need not learn it, but at least understand it. So clause 27, it defines the word control. Now, we will first mention that it is relevant for holding and subsidiary. You will also find the word control in other definitions also, like promoter. So what exactly is the meaning of the word control? But first I will write over here relevant for holding and subsidiary. HNS means it is relevant for holding and subsidiary. The word control shall include. Include means it's an inclusive definition. What is the meaning of inclusive? Inclusive means that they're trying not to define the word. See, when they use the word means, okay, like in company, section 2, clause 20, they have used the word means. Company means a company. It means they are trying to define the meaning of the word company. But when they say that control includes, it means it's an inclusive definition. It may include other things, but primarily this is what is included as of now. So it can include other things also. So it shall include the right to appoint. Now we'll highlight the keywords and also frame a mnemonic so that we remember the definition properly. So it includes the right to appoint majority of the directors or control the management or policy decisions exercisable either a person or persons acting either individually or in concert. It means together, whether directly or indirectly. The third important word over here is by virtue of either shareholding or management rights or shareholders agreement or maybe voting agreements or in any other manner. So over here we will write that how can you exercise this control? How can you exercise? You may have the right to appoint majority of the directors. You may have the control over the management or policy decisions. It may include by virtue of shareholding, management rights, etc. Now we will try to understand the definition in detail. So control will include, what is included? The right to appoint majority of the directors of the company. Now take the example of holding and subsidiary. Holding owns 60% of the capital of S. Holding has the right to control the composition of the board of directors. Now what is controlling the composition? You can either appoint or remove majority or all the directors of the subsidiary company at your own discretion. Now the same logic applies here also. How can you control someone? How can you control another company? By having the right to appoint majority directors of that company. See, the word appoint also includes the right to remove. See, law wants to shorten the language. Okay, we always want to shorten the language of law. So it is understood that if you have the authority to appoint, you will also have the authority to remove. That is understood. Okay. So the word control shall include the right to appoint majority of the directors. If you can appoint, you can also remove majority of the directors. See, if you can control the director, indirectly you are controlling that other organization. You can also have the right to control the management or policy decisions. So if you have the right to control the management decisions, it means you are controlling that organization. You are like holding is controlling the subsidiary by taking control of the management or policy decisions. Now, why? Okay, why will someone allow you to control the composition of the board? Why will someone allow you to take decisions for itself? Why will someone allow you to make management or policy decisions? See, it is very simple that you have given money against shares. So you have given money and you have obtained share more than 50%. Okay, so you have contributed to majority of the capital of that company. Because of that, by virtue of means because of that, they have given you the right to control the management. They have given you the right to appoint or remove majority of the directors. So by virtue of means it is because of my shareholding. It may be because I have some management rights or there is some shareholder or voting agreement, and because of this agreement, I have the right to control the composition of the board, or I have the right to management or other policy decisions. Okay, so it is because of the shareholding, management rights, shareholders rights or voting agreements that I have been given the power. So you may have either given lot of money in the form of loan and that is why I got this right, or you may have invested in the company. These rights, they have allowed you to appoint majority or remove the board of directors or participate in the decision. So that is the meaning of the word control. All right. Next, we have clause 28, which defines cost accountant. Not important for us. Quote again, not important. Clause 30, yes, it is important. Debentures. Okay, defines debentures. Now, what is mentioned in clause 30, debentures? We are going to study debentures in the chapter shares and debentures. So this definition will be repeated over there. But I feel that, the more we study, the more we revise, the better we will get at that topic. So don't worry. We'll repeat the definition. We'll study it again. We'll study it in detail. Consider that as revision. Okay. Now, what is the meaning of debenture? See, there are various ways in which company can raise money. You can either issue shares. But shares are basically issued when you require money for a longer period of time and you don't want to repay that money. But if your requirement is, let's say, for example, 8 to 10 years, then why issue shares and dilute the interest of the existing shareholders? Instead of that, go for debentures. It's like loan taken from the public. There are also deposits which we are going to study next. Deposits are for even a shorter period of time. Like say, for example, I need money for maximum 3 years. Deposit is another way of raising finance. Now, clause 30 defines debenture as, debenture includes, okay, this is also an inclusive definition. Inclusive means that they are not defining the word debenture. They are just saying that this is included in the word debenture. So it includes debenture stock, bonds, any other instrument of the company, evidencing, it means showing a debt, whether constituting a charge on the assets of the company or not. Charge means security, whether they are secured or unsecured. So this may be secured or not. It means it can also be unsecured. So you can issue secured debentures, or if you already have a goodwill in the market, you can also go for unsecured debentures. So over here, debenture includes debenture stock. Stock is nothing but an aggregate of various shares. Okay, it is expressed in amount. We are going to study that in Unit 3. If you have studied foundation under me, you will definitely know the meaning of the word stock. I had explained that in detail when we were studying in foundation. So debenture includes debenture stock, bonds. In India, the word debenture and bonds, they are used interchangeably. So there is not much of a difference, but yes, for our understanding, we can remember that debentures are issued by the company, bonds are issued by the government. Okay, there is proper difference, and that difference between I will give you when we study the topic debentures. So it also includes bond or any other instrument which is showing a debt. Okay, this is nothing but a loan taken by the company. So the company doesn't want to go to the banks. They charge, they ask for a lot of covenants. Okay, there are a lot of conditions. I don't want to go to the bank. Public is only interested whether we are giving them interest on time and whether the redemptions are happening on time or not. They don't question. They are not as particular as the banks. So yes, these debentures include stock, bond, any other instrument evidencing or showing a debt, whether they are secured or unsecured. Provided that, so this is a proviso. Proviso means that everything will be included in debenture. Whatever is mentioned will be included, but we are excluding certain things. Okay, we are excluding certain things. And what are they? Instruments referred to in Chapter 3D of the RBI Act 1934. So what is included in Chapter 3D of RBI Act 1934? Now, Chapter 3D excludes derivative instruments. Have you heard of futures, options, forwards? Yes. So derivative instruments will include forwards, forward contracts. Then you have options, swaps. These are not considered as debentures. Then we have money market instruments. There are separate rules for them. They are not considered as debenture. Money market instruments. Then we have securities of central or state government or even local authority. Repo, reverse repo. These are not considered as debentures. Okay, so they are excluded, and that is given under Chapter 3D of the Reserve Bank of India Act 1934. So they are not considered as debentures. any other instrument, okay, such other instrument as may be prescribed by the central government in consultation with RBI. So later we have given them the right to exclude certain instruments from the definition of deposit. So they shall not be treated, sorry, debentures. They shall not be treated as debentures. Okay, so this is excluded from the definition of debentures. Again, we are going to discuss this in detail later. Next, we have clause 31, which defines deposit. Now, have you heard of fixed deposits? Yes, you have some excess fund, you go to the bank, you take a fixed deposit. Similarly, the company is also accepting, it is inviting deposits from people that I want money for a very short period of time, like maximum I want for 3 years. People are saying like, yeah, we also want to invest only for a certain short period of time. Deposit, they are a good way of raising short-term finance by the company. There are specific rules. We are going to study that later. There is a separate chapter on deposit, section 73 to 76A. So we are going to study deposit. It means receipt of, we'll highlight the keywords, by way of deposit, loans, or money taken in any other form by the company, but it does not include such categories of amount as may be prescribed. We had studied earlier. Yes. See, whatever I have explained earlier has relevance. We are going to use all that during our lecture. Now, it does not include any amount as may be prescribed in consultation with RBI. So the Parliament, when they enacted this Companies Act, okay, so when they enforced the Companies Act, they said that yes, we will exclude certain categories of amount, but now we are not ready with that list. Central government, we are authorizing you, we are giving you the power to prescribe rules for effective management of the act. So yes, the central government will later prescribe rules in consultation with RBI and exclude certain amounts, and they will not be considered as deposits. So that rule is Rule 2 of Companies Acceptance of Deposit Rules 2014. Okay, this we are again going to study later when we study the act, but because we are defining certain terms, we are studying them, it is better to write. So Rule 2 of the Companies Acceptance of Deposit Rules 2014. In that, you will find a list of monies which are not considered as deposit. Okay. Next, we have the definition of depository, not important, derivative, no, director, not important, but yes, it is interesting. It means a director. Okay, so now they are defining it because the word means is used. It means a director, I'll highlight this. It means a director appointed to the board of the company. So when we define the word director, we are specifically mentioning that he is appointed where? To the board of what? Of the company. See, we need to specify which board are we referring to. Are we referring to the board of secondary education? Are we referring to the board of film certification? No, we are referring to the board of a company. So director is someone who is appointed where? To the board of what? Company. So it is so easy to remember. It means a director appointed to the board of the company. So here we need a lot of clarity, and law has given us that clarity in the definition. Then we have the meaning of the word dividend. Clause 35 defines dividend, and see, it is a very funny definition. Dividend includes, again it's an inclusive definition. They are not defining meaning of the word dividend. They are just simply saying that it includes interim dividend. Includes interim dividend. Alright, but before that we need to know that dividend may be either final dividend or it may be interim dividend. Now, what is the meaning of final dividend? Final dividend means the dividend which is declared in the annual general meeting. Proposed by the board, declared by the company in the annual general meeting. Interim dividend is a dividend which is declared between two annual general meetings. So, during the year, between two annual general meetings, whatever dividend we declare is interim dividend. Now, if you read the act, it is not practical to always specify whether we are referring the provisions to final dividend or interim dividend. So, law has simply mentioned the word dividend. Now, there is confusion. do these provisions apply to final dividend or interim dividend? So law has clarified that if we are using the word dividend, it includes interim dividend, which simply means that the provisions of dividend shall apply to interim dividend also. It means that whatever provisions that we are going to study in the dividend chapter, whatever provisions are mentioned, the word dividend includes interim dividend. It means the provisions of dividend will apply to interim dividend also. So every time we will not specify final dividend, interim dividend. We have just mentioned the word dividend, it includes both. We do have some extra or different provisions for interim dividend. There they have mentioned that this will apply to interim dividend. So if it is specified, very good. If it is not specified, the provisions are common for both final as well as interim dividend. Okay. Then we have definition of the word document. Document includes, again, it's an inclusive definition. They are not explaining meaning of the word document. They are just saying it includes what? What is included? See, I always ask myself questions. What is included? What? So see, it includes summons, notice, requisition means request, order, declaration, form, register. Not important for exam. We are just studying it for our knowledge. Whether issued, okay, sent or kept. Kept means maintained. Why are we maintaining it? Why are we issuing it? Why are we keeping it with us? Because it is requirement of this act or any other law for the time being in force. So it may be required either by the Income Tax Act, GST. So either this act, that is the Companies Act, or any other any other law. Why we are maintaining it? Because it is the requirement of law. That is why we are maintaining these documents. How are we maintaining it? I'm changing the ink. How are we maintaining it? We may maintain either in paper, you take a printout and maintain it, or in the electronic form, like you have an image, or you are maintaining books of documents, books of accounts in electronic form. You're maintaining certain documents in your computer, so that or in a drive, or maybe on a server. That means you're maintaining it in the electronic form. So what are the few words that we highlighted? One was what, then is why. I'm just highlighting so that you know that we need to ask ourselves 3 questions. So if you're learning the definition of document, you need to ask yourself 3 questions. What is a document? So document is summon, notice, requisition, order, etc. Whether issued, sent or kept. Kept means maintained. Why? It's the requirement of this act or some other law for the time being in force. And how you're maintaining it, either in paper or in electronic form. So if you ask yourself these 3 questions, your entire definition is learned. Yes or no? So students, this is how you will memorize the definitions. This is not important for exam, but anyways. So in this video, we discussed section 1. Yes, we discussed section 1 in this lecture. We started by discussing section 1. Then we discussed various other sections like section 2, we discussed clauses, abridged prospectus, accounting standards. What is the meaning of the word alteration? It means addition, omission, substitution, that is replacement. Alteration, articles, then it is originally framed, altered from time to time, or you can also adopt the model articles. Auditing standards, accounting standards, yes, they are recommended by ICAI to NFRA. NFRA will then confirm it. They will go through it and they will recommend that to the central government. So they will examine and recommend to the central government. Then we also discussed meaning of the word body corporate, and I also gave you a detailed table explaining the difference between company and body corporate. Then books of accounts, charge. We discussed charge means it is a kind of security. Company was defined, company limited by guarantee, company limited by shares. Then we discussed meaning of the word contributory. I made you write a note for that. Yes. After that, we discussed what is control, debenture, deposit, dividend and document. So everything was discussed in detail, and I think we will end the lecture here because we covered all the clauses till D. Okay, till D. Next lecture, I will continue with the preliminary chapter and we will try to conclude the chapter next time. After that, we will solve the relevant questions from the compiler. Okay, and with that, our first chapter will be over. So guys, please read this, keep revising, go through my notes and try to memorize the definition so that you are ready with the definition and with the learning part of it till your revision. Okay, so my aim is that you should learn, revise in the class itself so that you don't have to study again at home. But yes, one reading is definitely required. So go through these definitions and try to learn them, write and practice, and I'm sure you'll be able to memorize all the definitions.